DMV of fulfilling its obligations. Your Honors, I would ask you respectfully to reverse the Circuit Court of Kanawha County.
Case will be submitted. Thank you.
Next case for argument this morning, Men and Women Against Discrimination versus Family Protection Services Board et al., number 35558.
May it please the Court, my name is Robert Basters, and I am before you today as a Special Assistant Attorney General representing the Family Protection Services Board. The appellants seek review of a decision by the Kanawha Circuit Court that found several regulations that have been promulgated by the Board and submitted to and approved by the Legislature as exceeding the Board's authority under the underlying statutory provisions. The Court also found a Board rule requiring domestic violence shelters to have a plan to deal with special needs groups and populations with regards to whether the facilities can meet their particular needs. And furthermore, the Circuit Court struck down a rule requiring certain content in programs to train domestic violence advocates. Family Protection Services Board was created by the Legislature in 48-26-101 at SEC and was charged with oversight and licensing of domestic violence shelters in the case and with the regulating and licensing of what are called perpetrator intervention programs, more commonly referred to as PIPs. Also directed the Legislature also directed the Board to propose rules for submission to the Legislature for its approval. The Circuit Court, as I mentioned, found several of these rules beyond the Board's authority. Two of them dealt with the assignment of the certification process for domestic violence advocates to the Coalition Against Domestic Violence.
Well, I think we understand the basic underlying issues that were heard by the Circuit Court. Could you first address the issue of standing, whether there's any standing here on the part of this organization?
Yes. For a couple of reasons there aren't. The standing issues were dealt more fully in the amicus brief that was submitted to the Court by the Coalition. The standing on the rules dealing with how the shelters provide services for men. It's essentially the underlying case is that the Board discriminates against men. There simply has been there's no evidence that anyone has ever been denied services by any domestic violence shelters.
Was any evidence presented below, or was this treated strictly as a legal matter?
There were depositions taken. The depositions taken were of people who operate the domestic violence shelters and some representatives from the Coalition for Domestic Violence. There was no evidence submitted at any time about any individuals suffering discrimination at the hands of either domestic violence shelters or the Board or the Coalition, for that matter. Furthermore, there's serious standing questions with regards to the purported First Amendment claim that the challengers have made. The provision in question is a provision in the certification process or the licensing process for the PIPs, and the domestic violence advocates are instructed to be grounded in the fact that domestic violence is rooted in power and control over women. The MAWAD folks, the plaintiffs in this case, contend that that somehow violates their constitutional rights of free speech because the Board has dictated the content of this particular program. There are serious problems with that. For one, there's no allegation that the MAWAD has suffered any injury because of the existence of this regulation. So there's a serious standing question. No injury, no standing. And of course, on the merits, it is totally without any kind of authority whatsoever to say that the existence of a governmental program and the legislative prescription, or in this case, the administrative prescription of particular content to a program would interfere with a person's exercise of their free speech rights.
Well, are programs offered for, the perpetrator programs, are they offered for female batterers?
Yes, they are. And that's another standing question. There is not one instance in the record where any male came forward and said that he wanted counseling or PIP for his batterer, for his victimizer, where it wasn't provided. It is true that almost all the people in the PIP programs are men. That's because the overwhelming number of perpetrators are men. Figures range from 85 to 95% of the perpetrators of domestic violence are men. So you wouldn't be surprised to see the PIP programs in there. And if without a person who has suffered injury, there's simply no basis for, on which MAWAD can challenge this.
But aren't they saying that they have the right to petition under their free speech rights?
Well, nobody's questioning that.
Pardon?
Nobody would question
Doesn't that
that.
give them standing under the Norr-Pennington Doctrine?
No. Well, Norr-Pennington, of course, dealt with legislative activities, where the lobbying activities and the like, and there's nothing that the board has done that would interfere in any way with MAWAD's ability to lobby the legislature, to...
But it deals with administrative agencies, too, and they're complaining about regulations discriminating against men.
Well, they haven't identified...
I'm not saying it does. I just wondered what your take was.
No. Well, that's another thing. The lower court finds that that the board's, quote, rule requiring separate but equal facilities violates the spirit of the legislature, or the board's rule that PIPs are only for men and not for women as well. There is no such rule. Neither the Circuit Court nor MAWAD have identified any such rule. The rules are entirely gender neutral. They provide that for services to be delivered on a gender neutral basis. There was evidence provided by the deponents who work with the shelters in the coalition that there are programs available for women, women perpetrators. Now, some of the shelters use different programs, the thinking being that the problems and the issues that women perpetrators have are frequently, if not almost always, different from those that men have, and they require a different kind of counseling. There's a different content. Now, that's not true in all the shelters. The shelters vary as to what they provide for women perpetrators. But nevertheless, the services are being provided. It just may be a little bit different. The same thing is true when you get down to whether men are not being turned away from the domestic violence shelters. That is simply a misstatement. As I said, there's no evidence in the record that anyone has been turned away. And what the evidence does show is that each shelter, the evidence shows that the board requires each shelter to have written policies with regards to when their housing facilities are not adequate. It could be because they're at capacity, or it could be because they don't have the facilities to provide, to meet the needs of special needs populations. And that includes the disabled, the elderly, and adult men, and sometimes adolescent males. And the shelters vary in what they do. Some of them, in fact, house men on site. They have the facilities. They're able to provide those services on site. Other shelters do not have the facilities to house men and women simultaneously. So what they do is they put the men up at a hotel or a home for the shelter for the homeless, or in some cases with adolescent males with a relative.
Let me ask you one thing. I'm not to interrupt you, but I'm a little bit confused by the lower court's order.
Well, you have cause.
Did the court actually intend? It cites that it states that it's reversing one of the CSRs that's nothing but kind of introductory, 191.21, holding it null and void. But did they really intend to address the provision that requires that at least a third of the family protection service providers be certified.
Yes,
Did
and
the court just cite the wrong section?
Well, yeah, I don't understand the court's ruling with regards to 191.2.1. All that section does is set forth the scope of that particular series. It doesn't have any substantive component to it, and it's the same as the section 1 of every other series in the CSR. So I can't explain that.
And the second question is, what is the practical effect of the court's order if it were to remain in effect, the lower court?
Well, it would force the board to change the content of their program, and that is,
You could shut down the shelters.
it could have a serious interference with the shelter's ability to deliver the services at the quality level that they've been maintaining. And certainly, there's a reason that the board contracts with the Coalition for Certification. The Coalition is easily the most knowledgeable and well-trained organization in the state to deal with domestic violence issues, and similar organizations exist all across the country, and the states make regular use of their services to certify advocates. And these are very specialized positions, and the coalition is needed to see that they are properly trained. So I think the practical consequences are significant. And I would like to get in the argument, which leads off our brief, with regards to the fact that these are all legislative rules regarding the scope of the authority of the board. And the legislature, in this case, reviewed every one of these rules and enacted them into law through a bicameral vote signed by the governor. These are laws. The section is 69-4-5. It's in our appendix. It's something similar to that, which says the legislature finds that the board is authorized to issue these rules and cites the rules. It made a few minor modifications, but in terms of the district court's ruling that these rules are beyond the scope of the legislative authority, I mean, there's a conclusive presumption that they're not, now that the legislature has firmly adopted them.
One last question I have for you is, when the lower court made a sort of a conclusory determination that these rules violated the free speech rights of this organization, but was there any evidence indicating in what manner it was claimed that?
No. I mean, I don't know how the existence of a regulation setting forth, it's very similar to the cases I cited in our brief. The fact that the government takes a position on something, which of course that's what we elect government officials to do. We want them to take positions. They tell us what their platform is going to be when we put them in office, and we expect them to implement that platform. And that necessarily they're going to have to engage in speech. And just because some group disagrees with what that speech is doesn't mean their free speech rights are being abridged. Abridged means, which is what our Constitution uses, that their rights are being limited. And there's no way, there's no reason that every member of MAWAD cannot get out on a street corner this afternoon or buy a radio station and promulgate all that they want about the discrimination against men in our domestic courts and violence system. I mean,
We are looking at this case carefully, and obviously you may want to reserve more time for rebuttal so that Mr. Payton can have an opportunity not to cut you short.
I appreciate that. Thank you.
Please, court. First, I would disagree with Mr. Bastrous' representation that implementation of Judge Stuckey's order is going to have any catastrophic effects on the way that the programs for domestic violence in West Virginia are administered or overseen by the Family Protection Services Board, or the manner in which funding is allocated by the board through the Family Protection Service Fund. It would open the marketplace of ideas. It would make the board work harder to deal with the applicants for programs. It would. The fact is that the circuit court made a specific finding that my client is a constituent group which desires to engage in the practice of advocacy, which is defined in the rules, the assistance of victims of domestic and family violence, etc. They would like to do that, and the criticism that was voiced by representatives of my client in a deposition was that a program of certification has been established by the board, that's not important if that doesn't lend any status or imprimatur of validity to a domestic violence advocate, then why do we have it? I mean, they would like to carry out their advocacy with the title Certified Domestic Violence Advocate. That is something that's available. It's in the regs. However, they can't do that.
I don't want to disrupt the flow of your argument, Mr. Payton, but I am very interested in the standing argument. And I want you to outline for me why you think you have standing in this case.
If the only standing argument we can make is that there's a facial defect in this rule. Obviously, if our client, my client, is a public interest advocacy group and they want to have the status to carry their message with a position created by the Family Protection Services Board, that is a certified domestic violence advocate, why can't they apply for that? Why are there no standards?
What stopped? Has there any evidence that they applied and were denied?
Well, they can't because they're not. That certification is only available to people who are already employed by.
You want to be one of the certifiers? Your group wants to be.
No, I think it's fine if I mean. All we asked the board to do was rewrite the rule and eliminate the first requirement is that the certification for domestic violence advocates is closed to anyone who's not an employee of a program that's already licensed. And to set standards.
Did you all have any evidence, though, on standing that any male has been denied any service or shelter? Do you have any evidence at all that someone's been denied these things?
Been denied what? Certification? We can't apply for it.
No, any male has been denied shelter, any victim of domestic violence who happens to be male has been denied a service or a benefit or shelter that women are allowed to have under these rules.
We did not make that allegation. That was not a part of what we asked Judge Stuckey to consider. We said we would like to have the status of certified domestic violence advocates. We'd like to have the ability to apply for and be considered for that certification, that we would like to see the requirements for that certification, which no one could produce, no one from the board could produce. At my specific request, where is an application for that certification? I was told it's at the office. I was told it's in somebody's home. No one could ever produce an application for certification. There is nothing in these rules that says here's what's required for certification as an advocate. If you, a representative of MAWAD, want to carry your message with this, what's obviously an important designation, or they wouldn't put it in there, and there's no alternative to be considered. Indeed, it might make the board spend more time. They might have to rewrite this rule and put in some specific objective standards for certification, which we could then try and meet. And if we couldn't meet them, we'd have an administrative remedy. But right now, my clients are completely for it. That was our biggest complaint. And that could have been remedied quite easily, but the minor change in this rule.
I didn't mean to interrupt you, Justice.
I'm sorry. And again, I'm saying you're correct.
I want to be clear. What is the facial defect in the rule now?
Well, it forecloses anyone who's not already an employee of a constituent agency from ever applying for and receiving certification, the status of a certified counselor, a certified advocate, which we believe decreases our ability to convey our message. Or not my ability, my client's ability. Because the response is, well, they're not certified and we are.
I'm confused. And I thought you were complaining, saying the regulations, though, discriminated against men.
Well, in some regards, no. This is not a case where someone says, I went to a shelter in Morgantown, I was turned away. My clients would like to have the status of certified domestic violence advocates, and if it's important and it's in the regs, it should be available to those who can meet certain objective standards. It shouldn't be a procedure or an office or a designation that's closed to anyone who's not already an employee and only awarded on standards that are not published anywhere.
So you're saying that your organization wants to be a provider of services, or wants to be one of the individuals who are certified?
Sure. They would like to
Well, have you applied? Has the group filed any type of application? Is there any evidence of that below?
Well, that wasn't an issue below.
Well, you're raising
But
it now,
back
though,
at
as an
the-
issue. I'm not, you're really confusing me now. I thought the issue
We
was
can't
a
apply.
challenge to these rules.
We can't apply because we're not employees of the agencies. We don't have the status to submit an application because we're spec'd out by the rule.
Well,
That's
these
our
rules did
complaint.
go under, as the other side points out, you maintain, if I understood correctly, that these rules were inconsistent with legislative intent, but they did go through the whole legislative rulemaking process, did they not?
Well, I don't think, Your Honor, you take a look at the appendix to the appellant's brief, obviously a Chevron analysis was applied to these regulations by the circuit court. He determined and made a specific finding about the intent of the enabling statute. Now, what Mr. Basker says on behalf of his client is that the legislature, acting as a legislature, dealt specifically with these rules. Well, that's not the case. These rules were adopted by an omnibus act. It was no different from what you looked at in the Appalachian Power case or the Mangrum case. There are 18 different agencies across a wide range of activities who proposed rules who were promulgated and adopted at the same time. The reasonable assumption is the legislature didn't look at the specific provisions of these rules that we say are offensive, and therefore the Chevron analysis was appropriate.
Well, I'll be honest with you. I've read the briefs, but your argument today has confused me. It doesn't sound consistent with what you're arguing in the briefs. It sounds like you're opening a whole other issue. And if there is this issue of wanting to be certified, there's no record below indicating that there was an effort to have that done, is there?
Well, the law abhors the doing of a useless act. We couldn't, if no one can tell us where to get an application, and by virtue of the literal letter of this rule, we can't be certified, until the rules changed, what difference does it make?
Is this organization strictly involved with domestic violence law, or?
I don't think so, Your Honor. My understanding, they have been involved with child custody,
That's what,
divorce matters. Sure.
I'm hearing this, and not to denigrate anybody's position, but I can't understand why this organization doesn't get involved in something that's really a serious problem. I'm the one that wrote the law that said that family law courts really ought to pay more attention to giving non-custodial parents,
Well, domestic
which is
violence-
usually fathers,
Domestic violence is a pretty serious
if I may
problem.
finish, to have a larger, more meaningful opportunity to have a relationship with their child. That's an important issue. This every other weekend visitation doesn't allow you to have a real relationship with your child. But you're up here arguing about this. I can't even figure out what you want other than you don't like the attitude of the domestic violence coalition community.
Well, no, that's
and,
not.
And
That's not at all so, Your Honor. That's not at all so.
you're trying to accomplish.
What we're trying to accomplish is to see some objective standards promulgated in the rules that would allow constituent members of my client organization to apply for and attempt to achieve certification as domestic violence advocates, so that when they speak, when they lobby, when they try and promote their position, they can stand on an equal footing professionally with those who may have other ideas. That's a simple proposition. And domestic violence is a serious problem. If you've got an admittedly, 14 to 16% of the universe of population who are victims of domestic violence are adult and adolescent males, what if a group simply wants to advocate for them? And you're confronted with a rule that says you can't have a shelter unless you treat them as a special needs population. All that's required to make that rule inoffensive is simply to strike out that ending clause, which includes adult and adolescent males as special needs population. Leave it up to the board then to determine whether a proposal by a shelter or a program for special needs populations is appropriate without regard to gender. What's wrong with that?
Anything further you'd like to add?
No.
Okay.
Thank you.
Mr. Bastros, do you have any?
First on certification. The board's rules set out what the eligibility requirements for certification are. And what the certification process does is to make, quote, certified advocates out of people who work for the domestic violence shelters. And the board has a rule that a third of those advocates must be certified, have received the training from the coalition. If members of MAWAD want to become certified and to work in as certified advocates and work in domestic violence shelters, they can apply to the domestic violence shelters and be considered for employment and then become eligible for the certification process. They could also start their own shelters.
Peyton just said that they asked for applications and they asked for the rules and none were provided.
Well, I think the record on that is not unambiguous. I think that Ms. Julian, who's the director of the coalition, said that the applications were available and they could come in any time and get them, and that would not be a problem. The other thing MAWAD could do is it can start its own shelter. If it wants to provide special services to male victims of domestic violence, presumably it wouldn't discriminate, but nothing is stopping it from doing that. There is a licensing process by which one can apply to the board for a license to run a shelter. There are I don't know, fairly elaborate set of criteria by which those decisions are made, and there are provisions for provisional. I mean, there's a section on provisional licensing, so they can get the program started and then get their certification. There are no obstacles to MAWAD members becoming certified advocates that are any greater than exist for anyone else. They simply have to make the effort. And as for the Chevron analysis, even assuming the Chevron analysis applies, the circuit court turned it upside down. The Chevron analysis says, as Justice Cleckley articulated back in Allegheny Power, that if the proposed rule, or the rule that's been adopted, does not violate the legislative intent or specific provisions in the legislative act, and is a step towards implementing the legislative directive, then it passes the Chevron test. And what Justice Stuckey looked for in applying Chevron was to say you have to have specific authorization in the statute before you can go out and set up a certification relying upon a private entity. And that's just not consistent with Chevron. The legislature directed the board to create a licensing scheme, to have a certification scheme. The board went out and did that, and was simply implementing the legislative directive. And I would suggest...
Let me ask you, Mr. Peyton has indicated that special needs population, if you drop that out, to a degree it would solve a problem, but I'm not following exactly what he said.
Yeah, that particular provision says that each of the shelters shall have written policies to deal with special needs populations when the shelter does not have the facilities to handle them. And it includes men among those special needs because, I mean, let's face it, there are major privacy concerns that make the men a special needs population. Not every shelter can protect the privacy of the women there, or the men for that matter. And so they have to provide alternative housing. And the shelters cannot deliver the services in ways which, or at least not all the shelters can deliver the services that does not take advantage of alternative housing. And the notion that separate but equal living facilities for men and women somehow is discriminatory is beyond me. I mean, we have separate but equal facilities in prisons and in jails, and we have to separate them at some point. I'm sorry, Justice Davis.
Does the court have to address any of that, assuming, for discussion purposes here, that you're correct on the issue of standing?
I think it could avoid the entire case on the issue of standing, yes. No injury, no standing.
Well, one last question I have is that the case seems to have been argued extensively on the issue of whether there's an unfair denial of services or benefits to males. But now Mr. Payton's argued a completely different thing here, that being that they seek some kind of sort of certification that they're precluded from even being considered for. Now, is there anything below to indicate that, with regard to the issue of standing, that any organization has sought this certification and been denied on the basis of their views? Or
there is nothing in the record to indicate that anyone sought to be qualified as a shelter or were denied the opportunity to seek certification because of their point of view.
And on its face, the regulation says that the domestic violence services are precluded from operating in any type of gender discrimination.
That's true. It's grounds for disqualification of the shelter for the shelters to discriminate. And I'll add one last point, too. MAWAD here has sued the board. The board does not administer the PIPS programs. The board does not make decisions about admitting people to the shelters. The board is, the PIP referrals are made by judges and magistrates for the most part. The board's out of the picture. All the board does is set up the licensing scheme for the programs. It does not administer them. And I think you can make an argument that not only is there not standing, that the defendant is not the right defendant if in order to implement Judge Stuckey's order.
All right, I think we understand your position.
Thank you, Your Honor.
The case will be submitted. Thank you.